we've just been in discussion with my colleagues as to whether we're proceeding with Mboto today or whether they want to listen to the recordings. I think they would.
Where does Mboto come from? Natal? He's in retirement. He's told me he's retired in Natal.
Yes.
If he's here, we've got to assist him.
As a court,
because, I mean, really.
As a court, please.
Unless he himself chooses to say he wants to sleep over at the Sheraton Hotel.
Yes. And I foresee that the further question should not be that long, as he's already been.
Just make your application so that it's on records of the recalling of whatever.
Court pleases, my lord.
Yes, sir.
My lord, I have an instruction to bring an application for the recalling of Colonel Mboto, who has finalized his testimony and he was cross-examined in terms of Section 167 of Act 51 of 1977.
Is it not Act? Is it not Section 166, subsection 3?
167, the recalling of
Is it 167?
That's correct, madam.
Okay. Hello? I see.
Just confirmation.
This is the court, madam.
Yeah, just check. Is section what?
It's in terms of Section 167.
Oh, sir, yeah.
Run together with 186, my lord. The one, as I said before, is the court Meromoti calling the witness. The other is the defense making an application to recall the witness, but they are read together, my lord. As the court proceeds.
Yeah, so it's 167, Mr. Mugumezulu.
That's correct, madam.
Subsection 3.
Subsection 3.
We are quoting only that.
Only that aspect.
We are reading it together with 186.
That's correct, my lord.
Right? And also what?
That is all. That will be in relation to the cross-examination of the witness on certain aspects.
Yeah, you are aware of the provisions of the law. I mean, you're a senior counsel, are you not?
I'm aware, my lord.
Right. Just to recap, Colonel Mboto has already testified. Is that not so?
That's correct, my lord.
And he has already been cross-examined. Right?
That's correct, my lord.
The law stipulates, I'm saying they must bring the decisions. It is tried that once a witness has been cross-examined, it's possible for you to make an application and forward or present cogent, plausible reasons why the witness should be recalled. In this case, Mboto has completed his evidence, in other words. The only aspect which I think you are making an application for is that he must be recalled, but you recall that he was cross-examined by an officer of this court, Attorney
Mr.
Ramusipidi.
Correct.
And the law says no two legal representatives can cross-examine a single witness. Is that correct, sir?
That's correct.
That's the law. But this court, in fairness to you, I'll quote you the decisions. State versus Basson, State versus Yanti, where the principle is reiterated that legal representatives who represent a single witness are not, without leave of the court, permitted to cross-examine jointly that witness. If one legal representative like you are seated here, Mr. Ramusipidi has cross-examined, that is the end of the matter, unless there are extraordinary and compelling circumstances which impel you to recall this witness. And as I understand you, it is, you want this witness to be recalled for further evidence, for further cross-examination. The way I understand the law, whatever he has testified to and whatever he was cross-examined on cannot be, as a matter of course, be repeated. Is that not so, sir?
That's so. That is correct, ma'am.
Right.
That
Let's
is-
quote the authorities, because people will say, hey, the judge really, hey. Yeah. Let's just first read, you can do it that, Mr. Ngumuzulu. Let's just first read section 167, subsection 3. Maybe start with the whole section so that for the uninitiated it flows logically.
My Lord, may
No, I know you know the law, but just read it. So
may I
that there's
request, may I request my colleague
Oh,
to
yeah,
read
to read it. Yeah, fine.
for eyesight
Oh,
problem?
that's so.
Yes.
Mr. Ramasipidi. What is it?
My Lord, if I may read, Section 167 in particular
Yeah.
refers to, and I quote, 167, the court may examine a witness or a person in attendance. That deals with when the person is recalled by a court. Should I read that, my Lord?
Yeah, read it.
Okay. The court may, at any stage of criminal proceedings, examine any person other than an accused who has been subpoenaed to attend such proceedings or who is in attendance at such proceedings, and may recall and re-examine any person, including an accused already examined at the proceedings, and the court shall examine or recall and re-examine the person concerned if the evidence appears to the court essential to the just decision of the case. And then let's go to section 186. It says, the court may subpoena a witness. The court may, at any stage of criminal proceedings, subpoena or cause to be subpoenaed any person as a witness at such proceedings, and the court shall so subpoena a witness or so cause a witness to be subpoenaed if the evidence of such a witness appears to the court essential to the just decision of the case.
Yeah, fine.
Okay, is that what this is?
Yeah, so if we're at Edom with the law, let's just adumbrate the principle, just in case this case goes any other place. This is the case of the state versus Yanta. The citation is 2000. 1 in brackets SACR 287. It's a judgment by Van Zyl, as he was when he was in the High Court of the Transkei. I'll just read the last sentence, paragraph, which is important in my view. Finally, a matter that requires mention relates to the procedure adopted by the magistrate at the hearing of the application for bail. The appellant was represented by 2 attorneys who were permitted by the magistrate to take part in the conduct of the case to the extent that they were both allowed to cross-examine each witness. Mr. Carpenter, who appeared on behalf of the state, submitted that the procedure was irregular, as I do. I agree with the submission. When an accused person has more than one legal representative, only one may then cross-examine a particular witness. C. Ferreira, Strafproces en die Leierhowe, second edition at page 387, and see also Pretoria's cross-examination in South Africa and South African law at page 132, and see also Wigmore on evidence, volume 3, paragraph 783. The ratio against such a practice is to protect a witness from being exposed to protracted cross-examination and not to unnecessarily prolong the proceedings. Wigmore, cited at paragraph 783, explains it as follows. This tradition rests on the wise policy of protecting the witness from undue and confusing interrogation, as well as securing a system and brevity by giving the control of the interrogation to a single hand. Although the procedure adopted by the magistrate in the present case or the present matter was irregular, it did not in any way prejudice the appellant and does not affect the validity of the proceedings. Right? Hatzenbeck also, in the case of the state versus Basson, who was popularly known as Dr. Death, had this to say. He says it's in Afrikaans, exalted Modius. On page 533, that citation is State versus Basson, 2001, 2 SACR 537. Ratzenbeck, as he was in this division, had this to say. Dit word aanvaar deur die stad dat daar 'n praktykreël van Tuka se daai bestaan wat prysverhoor van een getuie deur meer as een regsverteenwoordiger van 'n besondere litigant verbied is. It's not allowed. Die argument is egter dat 'n buitengewone omstandighede die hof 'n diskresie het om af te wyk van die reël en dat hierdie sake omstandighede is. Ek moet aantoon dat die verdediging wat die aansoek teenstaan toegee dat die hof en so 'n diskresie het maar aangevoer dat in hierdie geval die hof nie behoort af te wyk van die reël nie. Volgens Wigmore en evidence, derde volume, bladsy 783 en die bogemelde reël gebaseer op 'n wyse beleid om getuies te beskerm van onnodige en verwarrende tuisondervraging en om akkoord en kragtenstelsel te versigtig en verstig. Die reël is 'n ononthoofde gevolg. Nie een van die advokate kon 'n geval uitwees waaronder normale omstandighede daardie reël afgewyk is nie. Ja, he says, not in South Africa. Once a witness has been cross-examined by one of the attorneys or advocates representing an accused person, once that cross-examination has been done by, for instance, Mr. Mgomezulu, Mr. Ramusipidi, he is not entitled as of right to do that because, as they say, cross-examination, although it is a right encapsulated in section 35.3 of the Constitution, it is not an absolute right. But me, being fair, I'm going to do like Basson in this case, where he allowed two sets of advocates to cross-examine because the charges were voluminous. And so he was justifiably entitled to use his discretion to advance the completion of the case like I'm doing. I'm going to relax that rule and with the proviso that what has been discussed and cross-examined by your colleague, Ramusipidi, is not to be done. Actually, I was intending that the record of the proceedings between Colonel Mboto, the cross-examination, the examination and the cross-examination by Mr. Ramusipidi must be at hand so that if you wander away from that evidence and cross-examination, I must be able to tell you that. But I take it as an officer of this court, you have heard me. So the cross-examination is allowed on condition that it goes from what was cross-examined here to aspects which you believe, after your consultation with your clients, those aspects were not covered by Mr. Ramusipidi. Okay.
God please, my lord. My lord, may I be...
Let's hear your learned brother. Maybe any comment, Munir?
As a court, please, my lord. Well, firstly, the sections quoted by my learned friend, I don't think they're applicable.
It's not 167, it's 166. Is that not so? Just read 166.
166, my lord, states...
That's what gives you the right in terms of our constitution,
yes.
our Criminal Procedure Act to cross-examine. 167 deals with where you want to recall a witness, etc., etc.
Yes, but 166 deals generally with the cross-examination of
yes, just read that.
Subsection 1 of section 166. The heading is cross-examination and re-examination of witnesses. An accused may cross-examine any witness called on behalf of the prosecution at criminal proceedings or any co-accused who testifies at criminal proceedings or any witness called on behalf of such co-accused at criminal proceedings. And the prosecutor may cross-examine any witness, including an accused, called on behalf of the defense at criminal proceedings, and a witness called at such proceedings on behalf of the prosecution may be re-examined by the prosecutor on any matter raised during cross-examination of that witness, and a witness called on behalf of the defense at such proceedings may likewise be re-examined by the accused. Subsection 2, the prosecutor and the accused may, with leave of the court, examine or cross-examine any witness called by the court at criminal proceedings. And then subsection 3A, if it appears to a court that any cross-examination contemplated in this section is being protracted unreasonably and thereby causing the proceedings to be delayed unreasonably, the court may request the cross-examiner to disclose the relevancy of any particular line of examination and impose reasonable limits on the examination regarding the length thereof or regarding any particular line of examination. And subparagraph B, the court may order that any submission regarding the relevancy of the cross-examination be heard in the absence of the witness. My lord, the court has outlined what the legal position is, and it's clear that from the authorities quoted by the court that cross-examination by more than one counsel should not be allowed unless the defense demonstrate exceptional circumstances. And in this instance, my lord, we haven't heard what those exceptional circumstances are. So we submit, my lord, that as it was mentioned in the Basson's case, that this rule can only be relaxed if exceptional circumstances are demonstrated. We would request that the defense should The court has already made a ruling, but our view is that the defense must demonstrate those exceptional circumstances.
Yes, Mr. Ngomezulu.
My Lord, just received instructions from Mr. Ramasipidi. The court has already made a decision or an order in relation to the application.
Yes, I have.
But what has come to my attention at the moment, especially on the submission that the state has made regarding the exceptional circumstances, it would be a futile exercise to recross-examine the witness if such exceptional circumstances could not be established at the moment, despite the fact that the court has already made a ruling. Furthermore, Your Lordship, is that it will be a difficult practical exercise without the transcripts of the examination in chief and the cross-examination to pinpoint the questions that are relevant in order to establish what could be exceptional circumstances that may warrant the witness to be re-examined, to be cross-examined again by another counsel. In the circumstances, as I've indicated, my instruction is to abandon the application despite the order of the court.
Okay.
Court, please.
No, thanks.
Ukuthi bekunesicelo sokuthi uKenan Mboto aphinde abizwe futhi senziwe leso sicelo uyena ke uadvocate uMngomezulu noma ke ebesebuziwe ke imibuzo uyena ke uMr Ramasipidi. Inkantolo ibisifunda ke amacala athile ke ayisibonelo noma ke asetshenziswayo ke nanjengomzekelo achazayo ke ukuthi akuvumelekile ke ngokomthetho ukuthi la khona ke umsola noma ke abasola benommeli asithi mhlamba babili ke noma bathathu ukuthi uma omunye ummeli sebuzile nowesibili futhi omele kwaleyo msola oyedwa nayo ke aphinda abuze imibuzo ufakazi besebuziwe kodwa ke yanquma inkantolo ukuthi cha noma kukanjalo kodwa izobanikeza ke ithuba lokuthi cha uMboto uKenan Mboto nekhosana ukuthi akaphinde abizwe kodwa ke manje mase bephinde bakhulumisana ke abameli bona ke bobabili bathi cha ke uma kuzodingeka ukuthi akuphinde futhi kuyolalelwa irecord ukuthi ke umshushisi ebe ekhulumisana ngani kanye noKenan Mboto uMr Ramasipidi yini ambuze yona babona ke ukuthi cha angeke ke ukuthi manje ke abasaqhubekeki naleso sicelo leso noma inkantolo ke ibisibavumela ukuthi cha basengambiza ke uKenan Mboto kusho ukuthi ke ummeli ka accused number 1 and number 2 abasaqhubekeki ngalesi sicelo sokuthi uKenan Mboto aphinde abizwe.
Okay, where's Kenan Mboto? He still has to come anyway, depending, of course, on the exigency whether. Yeah, he still has to come.
The ruling that
Yeah,
is
of
going to be
course.
made at the end, yes.
Yeah. Hello. Oh, Mr. Ramsey, I thought you were saying something. Okay, so we adjourn until tomorrow. And then for this evening, councils, all of councils were involved. Then they must listen to the tape, the recording, so that when we come tomorrow with the cross-examination, the cross-examination must not be staggered on the basis that asilalelanga le tape. We didn't listen to the tape. We didn't listen to the recording. So the afternoon should be used for listening to that recording. I'm told it's 3 hours.
Yes.
And then tomorrow, then we start adjourn for the cross-examination of Mrs. Kronje. Is he coming tomorrow?
Yes, yes.
Leyo sizobonana kusasa.
Okay, the court will adjourn.